Welcome to Law Talk with Peter Meyer.
Welcome to Law Talk with Peter Meyer. Peter provides personalized and professional representation for personal injury and wrongful death cases across Georgia, empowering injured individuals to recover financially and hold those responsible accountable. I'm Evan Mack, and today we're focusing on what happens when a child is injured in Georgia. This is Injury Claims Involving Children, What Parents Should Know. Peter, sir, welcome.
Hi, Evan. It's great to see you.
Great to see you. So let's get down to brass tacks. How are personal injury claims involving minors different from adult cases in Georgia?
Well, they're treated differently because minors under the law cannot consent. 18 is the age of consent, so they can't sign legal documents and contracts. And so the legal rights are different and require a parent or a guardian or a court-appointed conservator who has the legal authority to handle the claim to hire attorneys, sign any documents, and settle the case. And so that's one way how it's handled differently. And also the minor's claim in the injury context, which is our specialty, it's technically two claims, the pain and suffering and future damages like lost earning capacity, that's in the name of the minor, but the medical expense claim is in the name of the parent or guardian.
Can you unpack that a little bit more about who has the right to file that legal claim on behalf of the injured child?
Well, who has the right to handle the claim? It depends on the value of the case, but typically you have what's called a conservator, which is a person appointed by the probate court. They can settle any claim. You don't always want to go down that route because it has costs and requirements on top of that. So parents, specifically natural parents or guardians, meaning a birth parent or an adoptive parent, can settle certain claims, and certain claims will require a conservator. You'll also have court approval in certain other types of cases. So it depends on the value of the case and the status of the parents, whether they're married or divorced.
Speaking about that divorce, who could handle that minor claim if the parents are divorced? How does that get situated?
And that can get sticky. So either parent can settle a minor's claim. Now, unless they're divorced and one parent has sole legal custody, as per a divorce decree, then that parent with the sole legal custody is what's called the natural guardian, and they can settle the claim. Now, if neither parent has sole legal custody, either one of them can settle the case. And that's where we run into some complicated situations when we have separated or never married parents or divorced parents who don't necessarily agree on how to proceed. It is best to get them to agree. I have had cases where I have two parents who absolutely hate each other and an injured child. And if I'm successful, I'll get them to agree on how it's handled and who gets what and who gets to make the decisions. However, if the parents cannot agree, one of them or both of them can petition the court and ask the court to decide. And they will look at factors like who's involved in making the decisions, who has the child, how often. But that's not the ideal situation because it can cost a lot of money and get really ugly. So it's ideal if both parents can agree. And in our case, our firm we're representing the child's best interests. Absolutely. So that's always going to be number one in our firm.
Does that typically when a conservator comes in, when things don't go that way, or is that when you see it more often?
No, the conservator really comes in more often depending on the amount of the settlement. So if I can break it down quickly, who it can settle the case and what's required really depends on the amount of the settlement. So if you have an injury case for a minor and the gross settlement, the total of all the funds, is less than $25,000, you do not need any court approval. You do not have to have a conservator, which is appointed by the probate court. However, the parents in that case must hold and use the funds for the benefit of the minor, and they can be accountable if they don't do so. The second scenario is where the gross settlement is over $25,000, but the net settlement is less than $25,000. So let's say you have a case that settles for $30,000, but after attorney's fees and expenses and liens, it's less than $25,000. If that's the situation, you do have to get court approval, but you do not have to get a conservator appointed. And court approval can be either through the probate court in the county in which the child lives, and you file a petition to settle a doubtful claim, or you can have it in a superior state court and have that judge make the decision. The third and more complicated scenario is when the gross and net settlement are both over $25,000. So let's say you have a $100,000 settlement for sake of argument. That requires both a probate court appointed conservator and court approval of the settlements.
Mm.
And that can get expensive and complicated. So we want to, try to hash those out as early in the case as possible.
So Peter, what types of compensation can be pursued when a child is injured in an accident?
Well, the types of compensation are pretty much the same as an adult injury claim. You have medical expenses, which is in the name of the parent or guardian, pain and suffering, and lost earning capacity, which is, and other disability damages, and that's all in the name of the minor. So the difference is not in the type of compensation, but the difference in a minor's claim is to who has which claim. So the parent has the medical expense claim, and the minor has the claim for pain and suffering, future damages after they turn 18, such as future medical bills or diminished earning capacity.
Now we're talking about money as far as like how are settlements handled when the plaintiff is under 18 years old? How does that work?
Well, because they're not of the age of consent, they can't sign a contract. They can't have an account only in their name. You have to have a parent or guardian to receive the funds, or the funds have to be placed in an annuity or a structured settlement to pay out after the minor turns 18. And, and that also goes back into how you settle the case. So if the case settles for less than $25,000, you don't need court approval, you don't need a conservator. The money will go to whichever parent or guardian has brought that claim, and they are required to hold those funds for the benefit of the minor. If you have one of those cases where the gross settlement is over $25,000 and net settlement is less than $25,000, then we have to go get court approval. We don't need a conservator. And typically we will put those funds into a structured settlement for the minor. And the same would apply if the gross and net settlement are over $25,000, then you have to get a conservator and court approval. And that's where it gets more complicated.
But speaking of those protections, what kind of legal safeguards are in place to protect this child's settlement money? So, people can't get a hold of it or kind of like, take that away from the child before they get the appropriate age.
And that's an excellent question. And that's something that we deal with all the time. In this firm, my concern is that child's best interest. And I want to make sure that that money is protected for that child, used for their benefit, in many cases held until after they turn 18. So even though if the case is less than $25,000, yes, the parent gets the funds, but they are technically legally required to use that for the sole benefit of the minor. And if you get one of those cases over $25,000, you have to get court approval. That's when we will typically avoid unnecessary costs and try to purchase an annuity or structured settlement. Because if you have to get a conservator, like if you have a case over $25,000 net, you'll have to get a conservator appointed, and that can require purchasing a bond, filing an annual inventory, having a plan for the funds, filing annual returns. So what we like to do in most cases is avoid the unnecessary cost and purchase an annuity or a structured settlement. And you've seen these commercials on TV. And what that allows to happen is, let's say you settle a case for an 8-year-old. You take those funds and they're put into an interest-bearing account. And that interest grows tax-free in the minor's name, and it pays out after their 18th birthday. And, nobody wants to hand a big check to an 18-year-old. They're usually not going to use it wisely. I know I wouldn't.
I know I wouldn't either.
Yeah. So what you can do is you can structure it to do lump sums or annual or quarterly or monthly payments over a period of years. And we've had many cases where, the parents and the child are thrilled because they're getting a monthly or a quarterly payment from the age of, say, 18 to 25. And that allows them to pay for college or buy a car or pay for other living expenses, instead of giving that 18-year-old a big fat check that they're not going to spend wisely. So those are some of the ways that we protect the funds for the child.
So Peter, what happens when a child's injury causes long-term damage or maybe even permanent disability?
Yeah, those are tragic cases, and we have seen quite a few of those here. If the minor is going to need long-term medical treatment, rehab treatment, or so forth, you have to have a long-term care plan. Sometimes we will hire an expert to prepare that life plan, which breaks down the costs and the types of care. And this is all part of the negotiation process with the insurance company to show the amount of the settlement that we need to resolve this case. Or for a trial, these are the damages that we present to the jury. And that's back to the conversation earlier. That's the most important reason to put those funds in a structure or in an annuity that will pay for all the child's needs throughout the course of their life or throughout a certain period of years. And the other protection is to get court approval of who's going to be the guardian, who's going to be the conservator of the funds, as well as the payout structure. I have had cases where I didn't feel the parent was looking out for the best interest of the child. And I worked with the judge and worked with the court to present something that we could agree was for that child's benefit, that's going to benefit them long after the case is settled. Because our goal is to win not just the largest possible settlement or verdict, it's also to make sure that your child's interests are protected long after that case is settled.
Absolutely. What about schools? Can schools, daycares, property owners, can they be held liable if a child is injured on their premises?
Well, that's also a good question. Injury cases for a minor can be brought against, any tortfeasor or at-fault party as an adult can. So in this case, if you're talking about a property owner or a school or a daycare, they would have liability just as an adult's claim would have. Now they get more complicated, and we can do an entire show on each one of those. But for example, schools have sovereign immunity, so it's more complicated to bring those types of cases. You have to meet a higher burden. But what we see also a lot is school bus accidents where the driver of the school bus is negligent. So basically, the school districts are immune unless they buy insurance. So most school districts have an insurance policy of liability, and and the immunity, which means you cannot sue them unless the law says you can sue them. That immunity is waived to the extent of insurance. So with bus accidents, I haven't seen a bus accident with no insurance in many, many years. So so essentially any tort, premises case, car accident, slip and fall, wrongful death, any type of negligence claim that an adult can bring can also be brought on behalf of a minor child. And we have won, thousands of cases, represented hundreds of minors and their families. And our number one goal is to get that, as much as money as possible for that child and to protect those funds so they're used only for the child's interest.
So Peter, what's your best advice to parents who suspect negligence or may have caused the child's injury? What would you say?
The first thing, contact an experienced law firm that specializes in injury and wrongful death cases as soon as possible, even just for a free consultation. Because as we've discussed, it can get very complicated as to exactly who has the right to bring the claim and how long you have to bring the claim. I would say that the best advice is that a minor's case is more complicated than an adult's, and you need to get this consultation so the right party is presenting the claim. We can navigate the courts as best we can to avoid unnecessary costs and paperwork and get that highest settlement and get the most money into that child's structured settlement, and to structure that settlement in a way that really looks out for the minor's needs. That child's needs are our number one goal with any case. And so really give us a call as soon as something happens, and we'll kind of walk you through how the process works. And when it's done, you'll know we've gotten the highest possible settlement. There's no unpaid bills, and that child's money is going to be protected.
Peter, thank you so much for your time.
Thank you. It's a pleasure.
Right, and thank you all for tuning in to Law Talk with Peter Meyer. Visit MeyerLawFirm.net to learn more. And if this episode helped you, please like, subscribe, and share with someone that might find this information helpful as well. Thank you so much for joining us, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.